Finding Common Battlegrounds is an attempt by two brothers, one conservative, the other progressive, to have civil conversations about politics with a little help from their friends.
Hello, everyone. Hey, welcome to another episode of Finding Common Battlegrounds. This is the podcast that's dedicated to civil debate. We are a sophisticated podcast where we try to work out our differences. Instead of focusing on what we disagree on, we're trying to focus on what we agree on. And usually there's a lot more there than you would think. So today's episode is about the Supreme Court and the overturning of Roe versus Wade. And the question is, did the Supreme Court overstep into activism with the Roe decision? So I keep hearing activist judges, right? And that's where the question is, like, are the conservative judges now activists, and have they maybe overstepped? So that's what we're going to talk about. We got our usual debaters, Josh and Ryan Cragen. Ryan is representing the flaming liberal side, and Josh is representing the libertarian conservative side. So let's go ahead and jump into it. First, a word from our sponsor, Lux Bidets. So I was just thinking, okay, this is a little maybe R-rated, I don't know, but so I'm I'm on the toilet, and I'm wiping and I'm done, and then I go. I'm thinking I'm done. Anyway, I was one more time. I was in there, and I'm had a bunch of literal crap on the side of my butt that I didn't know was there. It was all in the hair and stuff, right? And I'm I would have gone up and just gone about my day with a big chunk and on the kind of the side of the crack. And I'm this wouldn't have happened if I'd had my bidet. So I used to have a bidet in my old house, and we haven't gotten a new one yet. And I'm I need to get one. And this is the problem. So
let's be honest. Nobody wants to admit it, but everybody's been there.
Yeah. So
it's true.
It was I need something to really,
get yourself clean.
When you hose it down, it's hosed down, and you know it's clean. All right.
Not quite R-rated, but PG-13.
PG-13, yeah. Okay.
My children would be laughing hysterically at that. That's the stuff that children's comedy's made of right there.
Indeed. Comedy gold for kids.
I'm going to, I like to just jump into this. This usually gets the party started pretty quickly. So like we said, do we have activist judges on this panel, and are they overstepping their bounds? I'm going to just jump into one of these questions. Let's see which one would be better here. Let's go with Ryan's. Ryan's question for Josh. Ryan or
Josh.
Oh, why do you have Ryan at the beginning of all these?
I do.
What? Okay. Okay. I'm sorry. Okay. No, this is quite Josh's question for Ryan. I got confused. Ryan, can we agree on the following? As the final arbiter of the law, the Supreme Court is charged with ensuring the American people the promise of equal justice under the law, and thereby also functions as a guardian and interpreter of the Constitution. Can you agree on that statement? Do you want me to repeat it?
No, Josh, explain.
This should be a super softball. Okay, this is literally what it says over the Supreme Court as you walk in is equal justice under the law or something like that, right? So what does the Supreme Court do? Okay, can we at least agree on this? What should be their role?
What their function is?
Yeah, according
their function is to interpret the law.
Okay, yeah. So interpret the law, ensure that it's fair for everybody, and to interpret the Constitution and make sure everything's constitutional. That's their mandate. You don't agree with that?
And not fair for everybody, right?
Yeah, that's the kicker, Josh, is they have made many bad decisions over the years that have not been fair for everybody.
Agreed, but this is what they're supposed to do. Equal justice under the law. That's what it says on the arch as you walk in.
Right. So we can certainly concede their job is to interpret the law. They're not supposed to write the law.
Agreed.
They don't, right? Because they don't literally write
They're not supposed to.
Right. But they don't write laws. They write interpretations of laws. So they interpret the law. I think the idea would be on that second piece about like equal justice for all. The all has changed over the history of our country, right? So when it was first founded, the all would have been landed white men, right? So equal justice for all is just those who are recognized as people. And that has actually changed over the history of our country. Originally, women had no rights and slaves had no rights. And if you weren't a landowning,
they had some
man,
rights. They didn't have all rights.
They didn't have all rights, right? So they didn't have the same rights
that's
as
actually important.
the all, right? So I think in principle, that's what they're supposed to do.
That's all I'm asking. I'm not saying that they've been perfect, because clearly they haven't.
Okay.
Right.
Okay. But
you're agreeing that that was what they're supposed to do. That's their function.
In principle, I think that would be the ideal.
Okay, let's just do 3 points if we can agree on it. Interpreting the law, yes?
Yes, absolutely.
Okay.
That is clearly their mandate.
Trying to provide equal justice for all, yes?
Yeah, but like contextually and historically, that's really
okay. But the mandate. I'm not saying that they've done it perfectly.
Right, but we also need to recognize that equal justice for all has changed, like who is included in all over time. That's all I'm trying to say there. Okay.
And they're interpreters of the Constitution. They're making sure things are constitutional, because that's what it's all based on.
Yeah,
now, you're not going to like that, but that is their mandate. That's what they're supposed to be doing.
Yes, but constitutional, right? Like we're getting at originalists versus people who actually think the Constitution's a living document, and can be interpreted in light of the fact that it's 300 years old.
Wow, you can't agree to that.
Well, because no, the Supreme Court justices don't actually agree with that. Do the amendments?
The liberals don't.
No. Clarence Thomas doesn't. Do the amendments count as part of the Constitution?
You asking me?
I'm asking you.
Amendments to the Constitution, right?
Right.
Yeah.
So Clarence Thomas would throw out almost all of them. And he's a Supreme Court justice and an originalist, right? So when you say their job is to interpret the Constitution, what exactly gets included in the Constitution? Is it just the Constitution? Is it the Constitution and the amendments? Do you see what I'm saying? Because even among the Supreme Court justices, they don't agree on that.
But
this is fascinating. So what do you think the Supreme Court should be doing? I think
they should be interpreting the law. That's their job, right? The idea that but
not according to the Constitution.
Well, wow. The Constitution was written a long time ago, Josh. If you look at what the Constitution includes, it actually specifies that 3/5 of a vote is given to
sure, and that was amended.
A slave, right? That's my point, right? So we got to kind of change the Constitution and update that a little bit.
It has been. That's what the amendments are.
Okay, so that's what I was getting at. What is included? Is it the Constitution and all amendments?
Oh, I would think so.
Okay, then if we go with that, then I'll say the idea is that they're trying to interpret the law and verify that laws do fit with the general framing of the Constitution.
Okay. Fair enough.
Though how they think about that, the Supreme Court justices disagree on a lot of those issues.
I will take that as an agreement. Ding, ding, wow. Josh.
That was such a softball, and that was such a torturous response. I'm kind of shocked, but I guess I shouldn't be.
All right, I'm going to move on to the next one. Josh, the Dobbs decision therefore removes any restrictions that can be placed on abortion and puts all those decisions into the hands of state legislatures. Josh, can we agree that this is what the Dobbs decision actually entails? Ryan, you'll have to explain what the Dobbs
I'm going to explain. Okay. So in preparation for our podcast tonight, I actually read the Supreme Court decision, which is Dobbs versus, whoever. So I read
the new one. Dobbs,
yes, this is the one that it's going to be called the Dobbs decision. Yeah. This is the one that just happened. It's like 230 pages. I didn't read all of it. I read about 80%.
This is the suit that provoked the decision to overturn.
No, this is yes. Right. So this is the suit that they're deciding on that ultimately led to the overturning of Roe and Casey. I didn't read the whole thing. I read about 80%. the last like 80 pages is the dissent. Okay.
It was
So that's actually
66 pages.
Yeah. So that's the part that I didn't actually read.
What's the premise
I read
of the suit?
of the dissent or the suit.
Yeah.
The suit is Mississippi's legislature passed a law banning, saying, abortions cannot be performed after 15 weeks, right?
Okay.
And this is a challenge to Roe because Roe had it at a later time. So they passed the law and somebody sued, and then it worked its way through the courts and made it all the way to the Supreme Court. Right. And that's how we end up with the decision that we've got. So I actually read it because I wanted to like make sure I had a clear sense of what was going on. And for my first question to Josh, I just want to summarize what the Dobbs decision does. So this is the decision that they wrote and they released. Okay. Obviously, the decision overturns Roe, right? So Roe v. Wade, and the Casey decision. So the Casey decision was about 20 years later, and it's more complicated. It does some different things. Casey supported Roe, but modified it a little bit. Okay, so there are changes.
Well, clarify it. Basically, it modifies it, getting rid of the trimester language, and it says if the fetus is viable, which nobody really asked for this, but yeah, that's my understanding of what Casey did.
Yeah, I mean, it changes the language a little bit. It also changes the justification for why abortion should be legal. So it changes it from a right to privacy to the 14th Amendment and the Due Process Clause. So Casey changes the motivation for it, right? So there are a couple of interesting things there. Regardless, Dobbs overturns both of those, right? Mm-hmm. So both of those are prior Supreme Court decisions. They are precedent that have been thrown out by this court, okay? The Dobbs decision states that the legality of abortion should be left in the hands of the states, period. Okay. So in the Dobbs decision, it does not say anything about abortion that should be legal. It just says the whole question should be put in the hands of states.
Yes.
The Dobbs decision provides absolutely no protections for abortion at all. In other words, according to the Dobbs decision, it is now constitutional for a state to prohibit all abortions at every stage from conception on, and those states do not need to provide any exceptions for the life of the mother, for rape, for incest, or for fetal viability. Dobbs removes all protections for abortion, all of them. Okay. So that's all I wanted to just make clear and get agreement on, that the Dobbs decision does in fact remove any restrictions that any state could put on abortion. It just says you can do whatever you want. This is now a decision that is in the hands of the state. Okay. Can we agree that that's what the Dobbs decision does, Josh?
You frame that so, I mean, the way you frame that is just so sneaky. The way you're putting that up there, and again, you're focusing on that super minority of cases, the less than 1.5% of cases that are rape or incest or danger to the mother. You're framing it that's what this is all about. It's kind of disgusting how you framed that. Let me counter with this, because I'm going to agree with you. I'll grant you.
You better agree with me, because this is just sheer fact.
But let me counter with this. Do you like voting? Do you like that your voice matters? Do you like that you can vote? Do you like that if there's an issue, you can go and cast a vote about that? Yes or no?
Sure.
Okay, that's what the Dobbs decision just did. Now you get to vote about something, because before it was Supreme Court justices 50 years ago, whom you don't get to vote for, established the law. You don't get a vote on that. They just decreed by fiat, this is the law, which is not what the Supreme Court does. This leads into my next one, actually. But I'll give you agreement. Yes, the Dobbs decision kicked the decision back to the states. Yes.
And removed any protections, which means states could literally ban abortion, period, with no exceptions from conception.
That'd be awesome.
Right.
Sweet.
Okay. So let's just be clear.
They're basically saying the federal government isn't going to weigh in on this. We're going to like completely defer.
We're going to punt this to the states.
Yeah. Okay. We got agreement. Ding, ding, Ryan. Good job. Okay. Ryan, can we agree that the Constitution makes no mention of gay butt sex? I thought that was a name. I was like Gary Butt. Gay Butt Sex. Okay.
I think
that would just be called anal sex.
But it doesn't sound as funny. Does it make?
Okay.
Does it? With your understanding of the Constitution, does it make any provisions for the protection of gay butt sex?
That would be so cool if it did. Like the founders, right? They're all like, one thing that we got to put in here is anal sex. Like, we got to protect sodomy. No, the Constitution does not have a provision protecting anal sex.
No.
Particularly among gay men.
Yes. Ding, ding, ding. That's the fastest agreement I think we've ever had in our podcast.
Okay, so the liberals have been up in arms with the Dobbs decision, saying, well, now they're going to go after Oberfeld, the gay marriage one.
Obergefell, yeah.
And they're going to go after
Lawrence.
I think it's called Fudgepacker v. Texas. Is that what this one's called?
Jeez.
Cancel me. I made a gay joke. No, Lawrence v. Texas, which is no sodomy. Okay, that's and I've had people blowing up my Facebook feed saying they're coming for all of these. And Thomas has said that we should come for all of these. The other conservatives on the court, none of them are going to do it, right? But Thomas said we should go for these.
We don't know, but Thomas in his concurrence did say that he wants to go after this.
Why? Okay, this is important to discuss. Okay, so Lawrence v. Texas. I'm using this one just because it's a funny one. I don't think anybody should go to jail for gay butt sex, right? If you want to do that, do that. It's not my thing, but I don't think anybody should go for jail for that. But I do think this is bad law. It's bad legislation. The Constitution makes no mention of this. Why? This goes back to what I asked Ryan a minute ago about voting. And maybe this is just a libertarian thing, but this really is how our system's set up. Everything should be decided on the most local level possible. Okay. If it can't be decided on the local level, then it should go, if it can't be decided on the county, then go to the state, then it can go up from there. Why is the Supreme Court weighing in on this when states could weigh on this? And again, I get that liberals feel strongly about this. I wouldn't. If they strike this one down, Lawrence v. Texas, and it comes up in the state, I'll vote that we don't have, legislation blocking sodomy. Okay, I don't think that's a good idea to put somebody in jail for that. But I don't think the federal government, on the federal level, the Supreme Court should be making these mandates. It just doesn't make sense to me.
Well,
why are they weighing in on this stuff that can be decided on a lower level and should be decided on a lower level?
Well, but it was decided on the lower level. Yeah. Well, what, Tom?
States are legalizing gay marriage. I mean, this is a thing, what, a decade and
2015. Yeah. 2015 is when it was when the court decided that case.
The court, yeah. And at that point, there was
there were some states that had not most states.
Really?
Most. No.
It wasn't most.
I thought it was most, but at least the majority.
They might have had the majority might have had civil unions, right? But not same-sex marriage.
That sounds right, but I'm not sure.
Yeah, I'd have to double check. Yeah,
maybe I'm thinking that of civil unions, but that's so. I mean, I'm thinking like the federal court should weigh in when there's so say there's certain like Mississippi's like, nope, we're not going to allow, we're going to keep slavery or something like that, right? Like, or we're not going to allow gay marriage or something like that. The federal court, like what should happen, right, is the federal court there would eventually a lawsuit would come up and then the federal court would decide on it and overturn it, right?
This is what Josh is saying shouldn't happen.
What I'm saying.
Let me give you an example that they just passed ruling on that teacher that was praying out on the football field, right?
Football coach. Yes. Okay.
This is provided for under the Constitution. The Constitution deals with, the Establishment Clause and
right. So you've
religion, all that stuff. So that is the Supreme Court's job to adjudicate, to interpret the Constitution when it comes to a football coach praying on the field. That's the proper place of the Supreme Court. They're what's the word I'm looking for? Translating the Constitution, right? to interpret the law. That's what they're supposed to be doing.
Yeah, but it sounds like you want your cake and you want to eat it too. Like,
no,
what's the difference between men in Texas who are having sex and Texas law that says this is illegal, and that's why it eventually worked its way to the Supreme Court, right? So literally people busted down the door. They knew that there were two men in there who were having sex, busted down the door. They arrested them because under Texas law, anal sex was not acceptable. So they broke in, they did that. And of course there was a lawsuit, and it goes first to local courts, then it goes to the state, then district courts or whatever, and then eventually works its way to the Supreme Court. How is that any different than a coach praying on a football field in Washington State?
What does the Constitution have to say about it? So this is going to come down to whether or not you believe in the Constitution, I guess, or if that should be the adjudicating principle that we go by, because the Constitution says nothing about it, right?
Says nothing specific about anal sex, but it doesn't say anything specific about prayer. It just talks about religion, the free exercise of religion.
So this is where the interpretation comes in. Okay, that's what they're supposed to do, is interpret things. So how do you what statute are you going to use to interpret gay butt sex?
This gets to my second point, actually.
Then let's go there.
Well, I want to hear. So we can agree that the Constitution doesn't say anything. Oh, you agreed. Yeah, we're done with that. Okay.
Yes, there is no explicit reference to that in the Constitution. I think there should be. That would be awesome.
Okay, let's segue into this question.
I forgot to read something. It's actually kind of important here. Well, all right. I won't even read the whole thing. Basically, Alito's his explanation.
Okay.
What do you call it? His concurrence or whatever.
Well, Alito wrote the actual decision. So he wrote the decision.
He talks about how when Roe was established, Ryan already mentioned this, it was kind of, this is a right to privacy thing.
That was the basis for it.
It's super vague. Well, let me just read it. The Constitution makes no express reference to a right to obtain an abortion, and therefore those who claim it protects such a right must show that the right is somehow implicit in the constitutional text. Roe, however, was remarkably loose in its treatment of the constitutional text. It held that the abortion right, which is not mentioned in the Constitution, is part of a right to privacy, which is also not mentioned. The Casey Court did not defend this unfocused analysis and instead grounded its decision solely on the theory that the right to obtain an abortion is part of the liberty protected by the 14th Amendment.
Yes, and that's what I'm going to talk about.
We discussed this theory in depth below, but before doing so, we briefly addressed one additional constitutional provision that some of the respondents to Michi have now offered as yet another potential home for their abortion right, the 14th Amendment Equal Protection Clause. So we can talk about that right now.
That's literally what I'm going to read.
Okay. Let me just mention this. I had a long list. Well, not a long list. I had a list of liberals who were pro-choice, right? And they all agreed that Roe and Casey are not founded in the Constitution. Even longtime defender of the reproductive and women's rights, the late Justice Ruth Bader Ginsburg agreed in 2013 that Roe was flawed. She would have preferred that the abortion rights be secured more gradually in a process that included state legislatures and the courts. Ginsburg also was troubled that the focus on Roe was on a right to privacy rather than women's rights. Okay, this is Ginsburg's admitting right there Roe's bad legislation. It's not based on
it's not legislation. It's bad law.
Okay, bad law. But that's the problem. It became I'll get to that in my third point. When the Supreme Court becomes a legislative body instead of a judicial body and makes these decrees and makes laws, because that's basically what they did. Even Ginsburg said this is bad law. Even she agreed. But go to your point.
I think that might be a reach.
Let's do it. Okay, Josh, can we agree that Clarence Thomas does not think women have a constitutionally protected right to have their life saved by having an abortion? Yeah, I gotta break that down. What are we saying? Can we agree that Clarence Thomas does not think that women have a constitutionally protected right to have their lives saved by having an abortion?
Does that make sense?
Yeah.
So the Dobbs decision, of course, it's a long decision. It's over 200 pages. It has the main decision, then it has concurrences. So these are justices who are like, I agree, but I want to add something. And a couple of them do concur, and then there's a dissent by the three liberal justices. Okay. As Josh already mentioned, Clarence Thomas wrote a concurrence. So the concurrence is him saying, yes, I agree with the general decision, but here's where I disagree, and I want to make this clear. So one of the more interesting elements of the Dobbs decision is that Clarence Thomas wrote a concurrence that comments on the 14th Amendment. Josh was just bringing this up. which was the primary justification for the Casey decision, not for Roe, as Josh already mentioned. Here is the passage from the 14th Amendment that is the key. It's not particularly long. There are multiple other passages. I'm not going to read them, but I think it's pretty straightforward to understand what this passage says, right? So, quote, this is 14th Amendment. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. Fine. Pretty straightforward. Here's the next part that's key. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. End quote. Okay. So this is the passage that Thomas is talking about, that Josh was just talking about, that Alito actually writes at length about in the actual decision. Here's where this gets really interesting. Clarence Thomas's concurrence argues that states can deprive people of life, liberty, or property so long as there is due process of law. He is taking issue with Supreme Court precedent that has used the due process clause to enshrine rights for people and then just rejecting that out of hand. Okay. In his mind, the courts don't give people rights. Legislatures do. Okay. In other words, if a state legislature decides that gay people should not be allowed to have sex, then that is due process of law and the Lawrence decision should be overturned. This is exactly what Josh was just talking about, right? The Lawrence decision is the decision that allowed everybody in the United States to be able to have anal sex. Okay.
Right. And we're saying that could get overturned because that one there's no life.
But that would refer to liberty, right? So there's a liberty piece in there.
Okay, liberty, right.
So life, liberty, and property, right? Mm-hmm. So it's pretty broad. You can put a lot of things under life, liberty, and property.
Right.
And this is what he's actually challenging as well. And Alito does too. What do you mean by liberty? They want to put a very fine line on that,
right,
and say, nope, liberty doesn't include this, right? Liberty doesn't include the ability to have anal sex.
Well, because you're right, because life, liberty, and property could be, you can extend that to almost anything. Right?
Yes, right. Yeah. And so Thomas wants to cut this down and say, the court doesn't get to decide any rights based on this. All those rights get passed to legislatures. So the Supreme Court is not going to protect anybody's right. Okay. Now just pause and think about this for a second. Okay. Likewise, if a state legislature decides that there should be no abortion exception for women whose lives are threatened by a pregnancy, according to Clarence Thomas, this is due process of law, and those women's lives are forfeit, and they have no constitutional protection under the Constitution because, as he terms it, and this is a quote from Clarence Thomas, substantive due process is an oxymoron that lacks any basis in the Constitution. So he's rejecting the 14th Amendment. That's what he's doing. Yeah.
Right. He
just said it has no basis in the Constitution.
No, substantive due process. That's a legal term. I should have looked it up. It is an oxymoron because it's either substantive or it's due process. But that's a legal term that they've been using
to justify protecting people's life, liberty, and property. Right. And he rejects that
to justify ruling by fiat from the Supreme Court. That's what he's saying.
Kind of, but
not kind of.
Well,
that's what it is.
I've got more quotes from him in this.
There's all sorts of constitutional scholars that say that it is a dumb thing, and the Supreme Court should do away with it because it's not due process. It's this weird justification, and we should bring on an actual constitutional scholar, Danny or somebody that knows this, because
he's not a constitutional scholar.
Let's
somebody better than us. But the point is that this is a justification for the liberal Supreme Court to pass laws that they want. I'll get to this in my third one.
Well,
let me summarize this because I just want to make sure we're all understanding. So it's basically like the 14th Amendment says there's protections for life, liberty, and property, but
under due process of the law.
Process, and Clarence Thomas is saying the due process would be done with a state passing the law,
right?
And if a state was like, well, we're not going to give you any exceptions for abortions, and even if you're going to die, then and you're saying that could create a problem, right? Where it would challenge against the 14th Amendment.
Absolutely. But Clarence Thomas is saying, nope, that's due process. We don't get to do due process. Okay, that's state legislatures. So he's rejecting the 14th Amendment. Is basically what he's saying.
So basically, if some women were dying, he'd be like, well, due process was done.
Yep.
Because the
state legislature did that.
And that's what they decided.
But this is precisely why this is a difficult moral situation, because you can make the exact same argument for the life of the child, right? Yes, you can. Because there's no due process for the child if the mother is unilaterally deciding to kill it. So you can run with this as long as you want, if I'm understanding your question right.
Right.
Well, I didn't quite finish what I was going to say, but
sorry. Okay, you got more. You want
to a little bit, just because
way deeper than we should be going.
No, I don't think it is. I really don't, because I think this gets to the whole reason, the whole big question. So we'll get to that, right? He later writes, quote, because the due process clause does not secure any substantive rights, it does not secure a right to abortion, end quote. Basically, his argument is that courts do not decide to protect rights based on due process. That is in the hands of legislatures, and state legislatures can, in the case of abortion, deprive women the right to life so long as there is due process, meaning they legislate it. Here's one final quote from Thomas in his concurrence making this point. Quote, considerable historical evidence indicates that due process of law merely required executive and judicial actors to comply with legislative enactments and the common law when depriving a person of life, liberty, or property. So, end quote. So literally what he's saying is all this due process of law thing means is as long as the state legislatures say it, then that's due process of law. And people have to comply even when it comes to violations of life, liberty, or property. That's literally the quote that he just put in here. I'm not a legal scholar, right? So Josh is right. We probably should bring in a legal scholar. But what he basically just wrote is it's a direct quote from his concurrence, right? Like I'm literally quoting him. He's saying all the due process is, if the state legislatures pass it, they can, that's due process, deprive people of life, liberty, and property. So the interpretation here is exactly what I said. Can we agree that Clarence Thomas does not think women have a constitutionally protected right to life, having their life saved by having an abortion? It's not constitutional.
I agree with I completely agree, Ryan.
I don't think so.
That's what he's saying.
Yeah.
He's saying that as a Supreme Court, we are not going to protect women's lives if a state decides that their life is forfeit because they want to get an abortion to save their life.
Okay. Josh does not agree.
Well, I don't know. I mean, essentially that's
what he's saying
could happen and
that's what the Dobbs decision did.
Yeah. And I agree with the Dobbs decision. It should be down to the state because, we're going down a road.
All right, we're going to move
on. Quasi agreement because that kind of feels like a reach. But
you guys and your partial agreement crap. All right, I'm moving on. Ryan, can we agree that the left tends to see the Supreme Court as a legislative cudgel rather than a judicial body? So okay, go ahead.
This is, in my mind, this is the most important distinction we should make here. Well, the conservatives have a supermajority right now. We could pass any law that we wanted. We could do whatever we wanted right now, right?
Wait, hold on. In the Supreme Court doesn't pass laws.
Right.
That's the idea. But what did the liberals do when they had the majority? They passed a law, and you can finagle around that however you want, but they passed a law saying abortion's legal and states cannot touch it. That's what the liberals did 50 years ago. Yes or no?
They didn't pass a law. They don't pass laws. They interpret laws. Right. So their interpretation was X, and that gave people the right.
We all get it. But what they did made it the law of the land. That
made it the interpretation of the law of the land.
Yes, but the Supreme Court ruled by fiat. You can twist that however you want. That states cannot say abortions are illegal. They did that.
Up to a certain point with all sorts of restrictions,
sure,
etc.
But they did that. Now, what did the conservatives do when they got the majority and could do something about this? What we could have done is say, no, abortions are all illegal on the federal level, And if you do it, states have no say in it. If you have an abortion, you're going to jail. They could have done that. Instead, what did the conservative justices do? They said, this is bad legislation. Let's send it back to the states where it belongs. Okay. So the liberals.
Bad legal interpretation. Sorry, you keep calling it legislation. It's driving me bonkers.
Yeah.
Everybody knows what I'm saying. And it is law. So do you see the difference of what the liberals did and what the conservatives did? The liberals used the judicial body as a legislative body to promote their agenda and to put into place their interpretations of the laws that become the law. The conservatives said, no, we're not going to do that. We're not going to rule according, because I would guarantee, with maybe the exception of Roberts, all the other conservative justices are pro-life, right? And they would like
they're anti-abortion. Let's call it what it is.
And fine, anti-abortion. So they would like to see legislation in place that would very much restrict abortion. They would all like to do that, right? But because they're actual judges and they're not being activists, they got rid of the bad legislation and threw it back to the states. But
you're saying it's better because they instead of enacting something, they just deferred that back to the states.
Well, instead of being activists, again, they could have just swapped the whole thing. They could have got rid of Roe and said, nope, abortion's illegal. Okay, they could have done that
because like California, it's still legal, and in Oregon, it's still legal to have an abortion, right? And it's going to be, probably more than half of the U.S. It'll still be legal.
Well, everybody will have varying degrees of when it's when you can get rid of a fetus or whatever. Okay,
exactly.
So the conservatives put it back to the people, gave the people the power. The liberals just took the power. They just said, nope, we're right. And what are the numbers right now? 75% or 70 something percent of people in the US want some form of restriction on abortion. Okay.
Wait, you're framing it that way? So you could also frame it as 75% of Americans want access to abortion, whether there's restrictions or not.
But they want some sort of restriction. Okay.
Okay, that's fine. But the vast majority of Americans want access to abortion. The vast majority.
Okay, fine. So now they get a vote on that instead of just having a Supreme Court of 5 conservative judges saying nope, no abortion, because that's what the liberals did, and that's what the liberals do. They use anything they can as a cudgel to push their side. And you're not going to agree with me, but that is what happened. The liberals used it as a cudgel to say this is what we want, and the conservatives went, no, we think the people should have the power.
Josh, I thought your question was saying, does the left view the conservative leaning Supreme Court as the legislative cudgel?
No, just the Supreme Court.
That's saying why
that's why they want to pack. I mean, like Pocahontas was saying today, and AOC is saying, let's pack the court.
Pack the court. And they want to throw a couple more liberal judges.
We need to take this back because they're getting rid of the legislation we like. And I know Ryan said not legislation, but it is. It's law. It's the law. Legislation. It's the law.
It's their interpretations of the law.
Okay, fine. But it's still the law.
But this is interesting because it goes back to the question we were talking about of truth and how we seem to live in a world where we have 2 different truths. And that's the same thing as the interpretation, right? Of like, we have these 2 that interpret laws very differently, conservative and liberal judges, and they can kind of see it in almost in any way they want to, right? So it's very interesting. All right, Ryan, what do you think? Do they?
So I want to concede something that I hope Josh recognizes. Like, this is an olive branch. When I read Alito's decision in Dobbs, I think I ultimately was convinced that Roe was a bad decision.
Okay, good.
Okay, I think that's actually fairly compelling. And like you said, lots of other justices, lots of left-leaning commentators, legal experts, I think agree with that. I think Casey's a better decision. I don't know that it's perfect. He fights really hard. He fights really hard to undermine Casey in there. I think Casey's a better decision, in part for this 14th Amendment stuff that I'll come back to with my third point.
Okay. I'll grant that. It is slightly better. It has some basis, a better legal basis for the decision they came to, but it's still wasn't good. It was still.
I think it was better, but that's fine. So
it was still judicial legislation.
Okay. So I am trying to make like olive branch here that I can see some of the points that Alito is trying to make. I don't know if you read Robert's concurrence, but he had a middle path. He had a middle path here that I thought was really interesting. No,
what was it?
He was saying his middle path was to change the language on like when it's acceptable, right? So to basically pull that out of Roe versus Casey, so states have greater say over when it's not acceptable, but not to just be like, no, abortion can be completely banned. He's like, that's way too big of a step. And it's basically all based on precedent. He did not want to throw two major cases of precedent just right out the window, which is what Dobbs does, right? There's a term for it. It's like, I would say 30% of Alito's decision is addressing why they're dismissing precedent. And it's a big deal, right? You don't really want to dismiss precedent. It is a big deal, Josh. Don't try and undermine that. No, he spends 30% of his decision saying this is why we're going to disregard.
It sets a bad precedent.
Bingo. Good one, Tom. Good one. He's absolutely, that was very good.
But you can make the counter argument that what was the precedent before Roe? Okay. The precedent for a couple hundred years was abortion was illegal. Okay,
it was more complicated than that. And he tries to weasel around that a whole bunch.
Who?
Lots
Alito
of states
or Roberts?
No, Alito. Lots of states did say that abortion was illegal, except to save the life of a mother. And he admits that, but then he glosses over that and keeps saying the vast majority of states made it illegal. It was illegal. It was illegal. Common law said it was illegal, but they always had provisions to protect the lives of women, of living women. And Dobbs doesn't do that.
Would you be okay with it if it made that one exception? If we said if the mother's life in danger, then yeah, you can do the abortion thing, but the rest of them back to the states. Would you be okay with it then?
Let's get to my third point.
Okay.
Always where it comes.
All right.
Well, this is always the problem with the liberal argument here. They hide behind the unholy triumvirate of danger to the mother and incest and rape. And we've already established on the podcast that that's 1% of abortions. So
it is a minority of abortions, but I've got
it's 1%, not a minority. It's almost negligible. And I would grant you all three of those. I've said this before. If you would just call the other ones what they are, but go to your third point.
No, okay, Ryan. Do you agree that the left-leaning Supreme Court kind of?
I think Josh is
their interpretation was more of a cudgel.
I would agree with Josh if he said both sides see the Supreme Court as activist. To just say that only the left sees it as a tool to get what they want. Come on. There's been literally a 50-year initiative by conservatives to pack the court so they could overturn Roe. That's been the whole purpose.
Not to pack the court, to retake the court. That's different. They're not packing the court.
Would you
We're
say
not
that
adding justices?
No, whatever. They're putting enough justices on to legislate, to use Josh's term, to push their agenda. That's what they're doing.
But it was honestly it was to allow people to vote. Do you not see the distinction?
Yeah,
it's a minor distinction.
It's not minor at all. It's huge.
It's absolutely minor.
You think
really? So what about their other decision that just said coaches can pray on the field? Right? They didn't punt that back to state legislatures. They made that decision.
It's obviously called for in the Constitution. The Constitution very clearly covers religion and prayer.
All right, let's move on. Josh, can we agree that women should have the right to life, even if that means having an abortion to save their lives?
Yeah, I've already said if you would get rid of the other 99% of abortions, I'll give you that one, no problem. Lock, stock, and barrel.
Okay, so here's my very relatively quick last point. If the 14th Amendment protects the right to life, but Dobbs does away with that protection for women, which it does, I think the only logical conclusion is that the Dobbs decision is not a reasoned, logical, or well-founded legal decision, but rather political activism. So, Josh, can we agree that women should have a right to life, even if that means having an abortion to save their lives? And if you agree with that, I've got a second piece that I'd like to see if you could agree with too.
Ooh,
Oh,
a surprise.
Your bonus
question.
Digging in the knife.
So you agreed to the first part, yes?
I agreed to that one last time we talked about
Yeah.
All right.
Well, whatever.
So if we can agree to that, then can we conclude that the Dobbs decision is a clear statement that women, once pregnant, have no rights, as stated in the dissent. Okay, and this is a quote from the dissent. Today, the court says that from the very moment of fertilization, a woman has no rights to speak of, end quote. So that was written in the dissent. And B is the end result of years of political activism by right-wing conservatives to undo progressive Supreme Court decisions like Roe, but also to outlaw contraception, which Thomas wants, anal sex, which Thomas wants to outlaw, and same-sex marriage, which he also wants to outlaw.
No, because he doesn't want to outlaw any of those. He wants to kick them back to the states, to the most
which effectively outlaws them.
No.
Which effectively,
what state is going to outlaw butt sex?
It was outlawed in Texas. And
How
my guess
ago?
is that was the 1990s when Lawrence was decided. We're not talking 60 years ago. It was in the 1990s.
Wow,
I'm pretty sure. Let me double check, but I'm pretty sure.
I'm still okay with it because I'm a libertarian. You should be deciding this as local level as possible. And if your state does something,
it was decided in 2003.
Wow.
So the case started in the 90s. Texas was.
Were they prosecuting people in the 2000s? I'd love to know that.
I don't know.
Okay, but if you live in a state where they're going to prosecute you for doing something you like to do, there are 49 other states to move to. But let me address your. Okay, what was your first?
Really? My first question.
You threw too much at me there.
I threw two in.
What about the women?
Sorry, I keep writing all this. I got thoughts, but yes. Okay. So, Josh, where are we at on this?
So, first question.
You agreed. So you agree that women's life should be safe. Okay.
Is the Dobbs decision a clear statement that women, once pregnant, have no rights, as stated in the dissent? Quote.
Okay.
Today, the court says that from the very moment of fertilization, a woman has no rights to speak of. End quote.
No, because that's not what it's doing. It's just kicking it back to the states to decide.
And
it's not saying you don't have rights.
Federal rights, right?
Yeah,
federal rights.
It's not saying that at all. And my further problem with that is you wouldn't even define on the podcast what a woman is. So you're really going to make an intellectually honest argument that now we can define what a woman is in this legislation because we're pissed about it, but when we're trying to push our trans stuff, you can't define what a woman is, and men can get pregnant. So
can we call that the red herring that it is and get back to the real question?
No, because it's not a red herring, because it just drives me. It's double speak on the part of the left, so they can
not at all.
They can frame that particular argument however they want.
I'll replace woman with mother. How's that?
Do you?
It doesn't work for the left because now it's birthing parent. Now they want you to use birthing parent because they want to say that men
stop with these bizarro anti-trans talking points.
Do you agree?
No, I don't agree at all. Not with that.
You don't agree that what the decision does is says a pregnant woman has no rights.
No, that's not what it says at all.
That's absolutely what it says. That the federal government does not get to. So the federal government does not get to dictate this. Federal government doesn't get to dictate that a pregnant woman.
That's all that is.
It's not a dumb reach.
It is. I'm sorry.
Okay, let's ask it a different way. Should the courts guarantee that women have the right to life?
What courts?
Every court in the country. Should women have a right to life? It's a very simple question. And I get that you're like, that's 1%.
No, of course they should.
And that should be decided all the way up because it's the 14th Amendment. That's part of the Constitution, as you stated earlier. The Constitution says, if we're including the amendments, that's why I care about this, that we should protect people's right to life. Okay, and Thomas is saying, nope,
That's
state legislatures.
He's saying you should go back to the state.
Right. And states can say,
this is
you don't have a right to life.
This is the problem with arguing with somebody on the left about this, because you're just hiding behind this tiny little minority. What's the percentage of women who actually are in danger with pregnancy? It's so minuscule.
You don't agree, Josh. You don't agree.
That's not what he's saying.
I totally agree with him.
Do you think that Thomas wants these women to die? Is that really the straw man argument you want to paint there? That he wants these women to die?
I'm not saying that. What he's effectively doing is saying the federal government does not get to recognize a mother's right to life. That's what he's doing.
That's silly. That's silly.
Okay.
Silly or not, it's a fact. That's what he's
doing.
No
agreement. Sorry, Ryan. No agreement.
Partial agreement, because he agreed that women should have a right to life.
Yeah, he agreed.
He just doesn't agree that the conservative justices just did away with it.
Bonus points for your bonus question.
Fair enough. All right. Tommy's take.
Yeah, you want Tommy's take, or do you want? Do you want to?
Well, I think we went through our points, right? So let's do Tommy's take.
All right. So I actually totally agree with Ryan on both those second and third question, and. So this is interesting because yes, it basically was saying a pregnant woman has no rights. I think the way you put it was perfect on a federal level,
right?
Because it's being interpreted at the state level, but I thought what you even said, Ryan, was good, was because you said most states have a provision to protect the life of the mother before Rhodes. So like. They're taking it into consideration. Now, if you had a state that was like you kind of hypothetically were saying, we're like, no, you have no rights, that would be a big deal, right?
I think so.
As soon as you had the first mother die.
I think so too. I agree with that. That's a problem.
Well, yeah. I mean, as soon as you had the first mother die, right, this would be a big thing, and you would have to address it.
Agree with that.
And then, so I think you're more on board, Josh, if you think about it. But
no,
except when so the other part was due process, because due process has been considered in the state law. Now, what's going to happen is this is what I predict is there will be a suit that eventually comes to the court that says that due process is not being considered in some it's going to be some weird situations that are and then this law is going to evolve more, right? We're going to see some further evolution with the law.
Let me just clarify my stance here, because I feel like I'm being painted poorly here.
Hang on. You can put that in your closing statement.
Okay. All right. Go ahead.
In the end, one of the questions was, because I think what we've become more nuanced. We're more nuanced at the state level, and I actually think that's good. And I think Ryan's right. I think there is going to be a state that's going to be crazy on one side, and there are going to be consequences for that. But I mean, I think that's we have that with tax laws, and we have that with everything, and there'll be an issue that pops up with that, right? And we have loose crime laws, right? And there are consequences for that. People are dying, and it's like, that's
different gun laws in every state. Good point.
Right, and I'm just saying that's the way it is, and like I don't know. If this, one of the things is like, I've heard crazy stuff people talking about crazy stuff of like, they're going to record our information and then they're going to release it. And they're going to be like, charging us, we're going to get convicted because we reported something here. And in fact, I was talking with my brother's girlfriend, and she was like, oh yeah, this is scary. I'm like, well, if you really wanted to, you could just like go to the other state and go do this, right? And she was like, yeah, but what if like come back and I get reported? I'm like, who's gonna report you? And they're like, she's like, I don't know, like, I'm like you're gonna go back to your OBGYN. They're gonna be like, you were pregnant a year ago and now you're not. And I was like, I just, to me, I feel like it's this was like a lot of the mask mandates that I've seen lately, where it was like, I think I was talking about this, where like the people went into the restaurant and then they were like, no, you have to have your COVID passport, and they just showed them their phone and they were like, oh, thank you.
Walked by, yeah.
And it was sort of like, it's a law, but not being enforced. I would be like, I've already even read some articles about people saying, well, we're not even going to enforce it. And I would be surprised if I saw many people, like people being turned in because they got an abortion out of state and someone found out, I'd be like shocked, right? This is like weed, where people go over the border to get the recreational weed and they come back and you're like, it's tons of people are doing it, and I don't think it's being prosecuted that much. Anyway, and then the last is like, I'll just leave it there. I actually think this was less of a big deal than I think that it's being made out to be. Right. And because I've read several articles that are like horror stories of what like the country's about to turn into. And I'm like, I don't think it's actually going to change that much. But, maybe late stage abortions in some conservative states it's going to be hard to do. And they're going to have to they're going to have to travel further. They're going to have to go somewhere to have that happen. And I'm like, I don't know if that's necessarily a bad thing. Anyway. Adding a little friction to getting the abortion, late stage abortion. But anyway, all right, that's Tommy's take. So because Josh, you were like, this is you're giving an easy one for Ryan. I'm like, I actually don't think it's that.
Oh no, I was just making a joke about that.
Oh, were you? Okay.
I had missed that you had written the question. I thought Ryan had
always putting in his own questions.
Yeah, I thought he had written the question. I was like, isn't this Tommy's job? And then I scrolled back to the text and I was like, oh, Tommy did write that one. So I was just making a joke.
All right, Josh. Well, you're clarifying because you feel like you're being stereotyped into something.
Well, my problem with Ryan's take on that third one is just I feel like he's just saying Alito wants these women to die, and that's like one of these weird things that the left and the pro-choice people do is you want women to die. No, I don't want women to die. That's stupid. Okay. When the decision came out last week or whenever it did, I saw this really cool post on Facebook from a conservative, and he said, I think this is a moral good thing. I like this, but I'm not going to crow about it because I understand that there's an awful lot of people on the left who their principle is that they're just concerned about women. And I'm not going to be a bad winner about this and make fun of them. They really feel deeply about concerns. They're genuine concerns. I respect that. And I do respect that for the people that's the case. That's not the case for everybody on the left. A lot of people just want abortion on demand and they're really cool with killing babies and they see no moral quandary with this. And this is an outreach, and Ryan hates this, but this is an outreach of like the left's push for hookup culture. Right? They don't want any.
Which doesn't exist, but that's okay.
Doesn't exist?
Nope.
What world are you living?
Keep going.
Wow.
But it's called reality, where I look at the statistics and see that younger people are having less sex than people in our generation.
Sure, whatever.
Okay, sorry, we'll just ignore statistics.
You just frame this anyway. I'm not going to go there right now. It makes me too mad. I largely agree with Tom. I don't think much is going to change. I think the left's throwing a big deal about this, and they're burning up all of these delivery centers and raiding the Arizona Supreme Court, whatever they're doing, all the stuff that they accused us of doing on January 6th or doing it all now. I don't think much is going to change. I think this is going to go to the states. The states are going to come out with reasonable legislation and say, let's not do late term abortions because that's freaking horrifying. I don't think much is going to change. But we got rid of some bad legislation. It's good. Good job. Thanks, cool. Trump. Good job, Trump.
Thanks, Trump. All right, wow. Ryan.
So one just quick point of clarification. The current estimate is that 26 states are going to ban abortion almost entirely, with the exception potentially of when a mother is going to die. So when you say not much is going to change, we're effectively saying that in those 26 states, it's going to be impossible for anybody to get an abortion unless they can prove that the mother's life is at risk.
Good.
Okay, you can say that's good, but that is change. That is massive change. Okay, so
good. I don't think it's going to be as drastic as he said. By what Tom said, people are just going to go to the next state over. But if it does, fantastic. We're saving babies. We're saving minority babies. Left should love this. Anyway.
But keep going, Ryan.
I'm trying. Somebody is throwing conservative talking points. I've got a heckler in the room today. I mentioned to my wife, who is a genetic counselor, that we were going to talk about this. And I said, I learned something else in reading the Alito decision. And that's that when that decision came out, and it has actually changed a little bit, I think, since he wrote it, right? So he wrote it back in January or whatever. But at the time that he wrote this, it was something like less than 10 countries around the world allowed abortions after 20 weeks. Okay. So the vast majority of developed countries do allow some form of abortion, but often there is a restriction, and the restriction may be 15 weeks, maybe 18 weeks, something like that. It was only about 10 countries that actually didn't have a restriction, and the US was or didn't have a restriction, or the restriction was after 20 weeks, right? And the US was in that because of Roe. So Roe put it after 20 weeks. Mm-hmm. And my wife and I were discussing this, and she said, well, as a genetic counselor, she deals with fetal abnormalities, right? So often these are abnormalities that a fetus has. Some of them are lethal, right? The baby is going to die. It's just going to die. She said a lot of those fetal abnormalities can't be detected until somewhere between 12 and 18 weeks. So the Mississippi law, and I didn't even get to this point, the Mississippi law that was written and led to the Dobbs decision changed the date by which you could have an abortion to 15 weeks. Okay.
Right.
And Roberts actually was like fine with that. Like, let's just change the date. But no, what they did is said, nope, we're going to throw this back to the states. And a bunch of states have said, okay, then we're just going to make it so no one can get an abortion. So basically what we're saying is a woman who finds out that her baby has, trisomy 13, right? So it's a lethal condition. She finds it out at week 17. Okay. And she's living in Mississippi.
Right.
She now has to carry that child to term.
Right. Or go someplace that'll allow it.
Wait, you said it's fetal, or it's fatal for the baby?
Yes, it's fatal. The baby's going to be dead. There are a number of conditions where this is the case. And what my wife was saying is, when you pass this legislation, you're basically telling all of these women who are going to have a baby with,
anaphylactic.
Not anaphylactic. It's ancentesis. They have no brain. Okay. So this is a genetic condition where the baby has no brain or the brain is outside. Right. So this baby's dead, or it's functionally living, but as soon as you pull it out of the womb, it's going to die within days. They're all going to be forced to carry these children to term if they cannot afford to fly to New York, or they can't afford to fly to California, or go somewhere else. They're all going to, and I get, Josh, you're saying those are the exceptions. There is no provision for the exceptions. But they're not making provisions for these. Do you see what I'm saying?
Yes.
And those are all of the abortion cases that my wife deals with.
So I think that's the due process suit that I was just talking about, that I predict you'll get some edge case scenario that's going to come up and said, hey, your due process hasn't accounted for this, and it'll go to the Supreme Court, right?
How many people?
Yeah, but the Supreme Court currently is just going to punt.
How many people do you personally know that wouldn't be okay with that? That if there's some crazy thing going on where they wouldn't say, oh, let's make an exception. This crazy flaming liberal I was talking to the other day, he's like, yeah, the Mormon church is actually really good on this because they're really cool about making exceptions when it comes to abortion. They're anti-abortion, but when it comes to the life of the mother or whatever, they're really...
I don't know that the LDS Church's current position would account for what I just described.
Okay. Right. It's a totally off case.
No, it actually would, because they say if there's any kind of medical decision, it should be the family and the doctor making it. That's actually the stance, which I don't personally know anybody that's so flaming crazy Christian or whatever you want to call it, so zealous in any belief where they'd say, no, if the baby doesn't have a brain, you gotta go full term.
Okay.
Who the frick's gonna say that?
Josh, I agree with you.
Maybe it'll happen.
But the law has no provision for that right now.
Okay. So it will, as Tom's saying, it'll go back to the states, and then they'll start making their legislature, and somebody will go to the doctor and find this, and then they'll go, hey, we need to make an exception, and then they'll start making provisions for it. You're making these impassioned pleas on these super edge cases, and you're not talking about the other 800,000 babies that are being killed out of convenience. You hate that phrasing, but that's what it is, and that's what I care about. Let's look at the statistics. And you're making impassioned pleas about these really sad edge cases. Agreed. I agree with you 100%. That's a sad case, and I don't know how your wife deals with that, because that would wreck me. That would absolutely wreck me. But it's an excuse. It's like a cop out. It's hiding behind it. And we've already talked about this. I agree with you on that stuff. We should have provisions. This is nuance.
We don't right now is the point.
Right. But we will.
Right. Well, you'll have some mom take it full term, right? Some dead baby, and then people will be like, "Oh, we've got to come up with a."
Well, hopefully, it doesn't even go that far.
Well,
people are fairly reasonable. You're painting everybody as
I don't
crazy
think people
zealots.
are necessarily reasonable on this one. The other edge case, if you will, that just came up. A friend of mine posted this. He's actually a libertarian, but he posted this and said this is going to be one of the issues that comes back and bites the Dobbs decision. A woman was arrested for miscarrying. So she miscarried her child and somebody accused her of having had an abortion. Can you tell the difference?
Really?
Well, but how do you tell the difference?
Right.
I'm not a doctor. I don't know.
There's not an easy way. I mean, you have a miscarriage, right? So people know she's pregnant and then she miscarries the child and somebody accuses her of abortion. She got 3 years for that.
Oh, interesting.
So we have them at both ends, right? So there's going to be these challenges of people getting a miscarriage and somebody's like, I knew you were pregnant and you didn't want that baby. You had an abortion. They're going to be like, I didn't have an abortion. I had a miscarriage. How do you tell the difference? Okay. So those are going to get legal challenges. And the current course is just current court. Yeah. But the current court is just going to punt back to the states. That's the issue. Right. So if the state says, no, this is our position.
She was convicted and got 3 years.
She was convicted and got 3 years.
I don't know that they will punt it back to the states because they got rid of bad legislation. And you agreed Roe was poorly decided, the justification was pretty poor. Okay. Casey was better though. So, and they overturned Casey too. Not that much better.
Casey situates it in the 14th Amendment, which is the very issue that we were talking about. It basically says women still have a right to life. And they're like, no.
That's not, I mean, it's a straw man argument you're making.
It is not a straw man. They're saying that the federal government does not guarantee the right to life. I'm not saying that. I'm saying the federal government is not guaranteeing a pregnant woman's right to life.
If
they're not going to protect
it's been due process, right? Yeah. And I agree. I totally agree. And yeah, I completely agree.
Well, I think we found our impasse. I think we found some common ground, but now that's going to be our impasse. That I feel like you're painting the conservative justices as being anti-women and wanting to kill people, and that's just not the case.
That may not be the case for some of them. I think Clarence Thomas is straight in that because he immediately went after like 3 hot button issues, right? That are progressive issues. He's like, we need to overturn same-sex marriage. We need to overturn contraception, the right to contraception, and we need to overturn gay sex.
Yeah, on the basis that the federal that shouldn't be decided on the federal level by the Supreme Court. They should be state issues. That's his reasoning.
Why
not that he hates gay people.
Why didn't he go after interracial marriage?
I don't know. Is he married to a white woman?
He is. Interesting, right? So that's pretty convenient that he's like, I'm going to go after 3 issues that are hot button issues for conservatives, but this whole interracial marriage thing, no, we're not going to touch that.
Totally good.
Yeah. Activist judges, are they activist? Come on. He straight up said his agenda is. He put his agenda right in his concurrence.
That's interesting.
His agenda was to send things back to the states. Damn him.
Yeah, that's interesting. Well, that was cool. I actually learned that was a lot, and that was and again, I think we got a lot of agreement. So but that was very interesting. And that's really what I want to get down to was like what was their thinking and was it correct? And so that was interesting. It's going to be interesting to see how this plays out. And because I know there's going to be a couple cases in some conservative states that are going to flare things up again, right? Because they're going to be like, this woman died or whatever, right? And these things are going to come. It's going to be interesting to see how the states handle it and how the Supreme Court deals with it in the future. So but anyway, I thought it was fascinating to me. So I thought that was a fun episode. And I think, like I said, I think we got mostly agreement from each other. So
I actually didn't like this episode because I don't understand the law well enough to really feel like I had a really perfect grasp on this. Not that I understand anything that well, but this one was hard, I guess is what I'm saying. This was way harder than normal. And I didn't have a lot of time to prepare, but
yeah. I have to admit, it took me a long time to read that decision.
Yeah,
it's huge.
You had done some digging. So
yeah.
And I had a little time to skim it, and I heard some people talking about it. I was listening to some podcasts, but I guess there's a reason we have professionals trying to determine this crap. This is
I thought, because I think Ryan was disadvantaged on this one. This one was skewed more toward in my opinion, but like
why?
Well, I think I agreed. I mean, like everything Ryan brought up, I totally agreed with. And it sounds heartless, but I think it's what you were saying, Josh. They're just deferring it down to the state level. And the most states have provisions for most of this stuff. And there's going to be some weird outliers. But I think that's just like it's kind of what we're saying. It's just like anything. It's like, they have different gun laws and they have different things in those lives. And that's why you live in that state or this state or not this state, right? Sort of like it's all built in. So
if you look at the inverse of what happens there, if we just decide everything on the federal level, especially with the Supreme Court, who you don't vote for, your vote doesn't mean anything. You suddenly have no voice. But if you get to go to your county council meeting and yell at your county councilman, you have a voice. I don't have a voice in the Supreme Court, but I do have a voice up at the county council building. So I absolutely agree with the idea of throwing it back to the states, and I agree with Ryan. There will be some injustices, but I think it's worth it. I think it's far more important that the people have a voice. As sucky as that will be for that first lady that Tom's talking about, who's going to carry a baby to term, and it's going to cause legislation, but it's too important that we have a voice.
Awesome. Well, thanks for tuning in, everybody. That was a fun one. We'll talk to you later.
Josh, we may not always agree when it comes to politics, even though we're trying, but there is one thing we agree on. There is only one way to clean up after going to the bathroom, and that's with a Lux bidet.
I've been a proud owner of a Lux bidet for years. I have literally owned a Lux Neo 320 since 2013. That's the warm water model. Talk about happy, fun, poopy time. When I leave the bathroom, I know I'm clean and ready to talk politics in a civilized manner.
Exactly. Using a toilet without a bidet is about as uncivilized as it gets. Civil conversations demand civil hygiene practices.
And that is why our listeners should get themselves a Lux bidet.
And just to be clear, Lux is not supporting one side or the other in this podcast. They support civil conversations and clean butts.
We hope you enjoyed this episode of Finding Common Battlegrounds. The music is by Ben Sound. The views expressed in this podcast are those of the participants and not those of their employers. For more information or more episodes, you can find us at findingcommonbattlegrounds.com.